Hi everyone. I'll probably have to keep my glasses on because my vision isn't what it used to be. Thanks to the MGA and also the National Club Association. I really mean this. Organizations like you that help really foster the game, help all these clubs out. It's really important that we all stay involved with you. Thanks also to all of you. I mean, when I look out at this group, it could be any board meeting at any club. I mean, we're really the stewards of the game. I think we have to always keep in mind what's best for our clubs, how we can work together. Oftentimes we're competing with one another for the same asset, which is members, but at the same time, you know, you have to look out for your membership. You have to be a real steward for your club, how to protect that club. And you know, although we heard the request for higher dues with the NCA, I doubt many of you hear that from your members. So this topic here has to deal with that directly. Caddie's independent contractor status is something that's certainly gaining some momentum out there. Most people prefer the status quo. They have their own way that they manage it. People are not, the caddies are not on phone workers. The workers are not on a payroll. They're not covered by benefit plans. This is for most clubs. They're paid directly by the golfers. Caddies are generally happy, and they've sort of always been treated this way. Some people would say, well, if this is good enough, why do we have to mess with it? The answer is probably not good enough. Our clubs oftentimes are controlling report times or end times for caddies. They're assigning caddies to golfers. They're establishing fee schedules. Some clubs even handle the cash that goes to the caddies. A lot of clubs are using the caddies to perform other functions, jockeying, carts and bags, range picking. A lot of clubs discipline caddies. You're not doing it at a board level, but the caddy master, you know, if a guy shows up late, he's not going to get out. If he doesn't come in one day, he might not be able to get out at all the next couple of weeks. And then they end up sitting there for long periods of time. A lot of clubs have no records whatsoever to support an independent contractor status, which is, quite frankly, the way most of you ought to want to have the caddies categorized. There are some clubs who actually do categorize caddies as employees, but there are very few of them. Also, a lot of clubs require caddies to be trained, wear specific uniforms. They prohibit caddies from working at other clubs. Some clubs, and we've all heard this, and I'm a big proponent of walking in the game, but some clubs are purely 100% walking clubs. There's no other way you can go out than with a caddy. You have to think about whether some options are needed, whether it's carts, whether it's carry your own clubs, whether it's push cart, and those are things that may make some people think that it eats at the tradition of the game, but at the end of the day, I think you have to really start considering those options to make available things for the players to use other than just the caddies, and really keeping in mind the tremendous amount of really liability that could arise from a caddy as an employee situation. Why does this matter? Well, there's some old lawsuits that have existed over the years. In fact, my club, I'm from Essex County Country Club. It's the oldest club in New Jersey, an 1887 club. There's a 1934 case involving Essex County in which the club was sued by a caddy who got injured on the property. And in an effort to avoid liability, by the way, I wasn't there in 1934. It could have been my dad. But they were trying to avoid liability for the claim that the caddy had in court, and they were trying to establish that he was an employee, so that he would have been covered by what was the precursor to workers' compensation law at the time. It's also long before a lot of different legislation existed with regard to wages and hours and conditions and overtime and things like that. There's another case more recently, and also in New Jersey, that dealt with this issue, but again, it's back in the early 90s. And same thing, the club was trying to make sure that the caddy who got injured while on property was covered by workers' compensation policy. The lawsuits we're seeing today, and I'm not going to name any clubs, but we have them in New York, they're in California, there's also one in Florida, New Jersey. We recently had a DOL action. You know, you said that the DOL generally doesn't want to get involved in it, and that happens to be true. But if they get a complaint, they will pursue it. Very recently, we had a DOL complaint at a club that I'm helping out. And we were able to get it resolved for next to nothing. And I do think at the DOL level, it's the Department of Labor in New Jersey, maybe in New York. It's an issue they really don't want to take on. But if they get a complaint, they're going to have to follow up with it. What does it mean if employee status is found? So this is the liability part. You know, there's a minimum wage law. You have to pay people a certain amount. You're not going to have any records for most of your caddies, I assure you. Nobody here could swear, other than the caddy, that they pay how much these caddies are making day in, day out. So there's minimum wage law, which means you have to be paid for every hour you're there, whether you're waiting to work or whether you're actually working. There's overtime, which after 40 hours in a week, you have to get time and a half. Workers' compensation, unemployment insurance premiums and taxes, employment taxes as well. These are all things which could add up. And, you know, frankly, for some clubs that might have 100 caddies, you're looking at a number that's probably 7 digits long if there's a liability, as opposed to something that's a $20,000 problem. I know you mentioned that before. That's something that clubs can eat. A 7-digit problem, try passing that on to your members, and I think you guys will all be looking for new boards to sit on. What does the law provide? So there's different tests in every state for multiple different things. They all focus on one general theme, which is how much control is the club or the employer. This goes well beyond just caddies, but it also goes into the area of, you know, every different kind of employer that you have in the state. Very frequently, people want to call folks independent contractors. It gets challenged quite a bit. So in New York, degree of control, number one, clearly the number one inquiry that the courts are going to undertake with regard to this, you know, does the worker get engaged at his own convenience? Were they free to engage in other employment? Did they receive any fringe benefits, or were they on the payroll? Those are sort of clear indicia that I'm sure none of you are doing. Were they on a fixed schedule? You know, the New York law is very similar to the federal law under the Fair Labor Standards Act. The Department of Labor has a slightly different test. They look at supervision, direction, control, and do they generally offer their services up to the public. A lot of these clubs, when you look around today, and I know for certain that it exists, you know, the Caddie Master, which is probably a bad title. It might be something that we need to change at all the clubs, maybe call them a starter, maybe call them director of outside operations. Those Caddie Masters are probably communicating messages to make sure they have enough caddies for all of you every time you go out, and they're telling folks, look, you can't go work someplace else. That's exactly the opposite of what you want to do if they are independent contractors. We don't mind if they make the choice each and every time to come to Plainfield Country Club, or to come to Essex County, or to come to some club that they usually caddy at. And frankly, that's a place where they can use their skills to the best because they have knowledge. But we don't want to force them to do that, and we also want to encourage some level of interchange between the clubs. That's where you all can cooperate with one another. In terms of independent contractor tests, there's another, for unemployment inquiries, there's a slightly different one in New York as well. New Jersey, my home state for basically my entire life. In 2015, they adopted one of the hardest tests. And I just have you focus in on the second bullet there, which is it outside the usual course of business for which it's performed, or that is performed outside of all the places of business of the enterprise for which it's performed? Really tough part of this new ABC test that's court adopted in Cargo versus Sleepy. It may be the death knell to independent contractor status for caddies. I'm not giving up on it though. I think you can get out of this, but I think that's where having other choices at the club takes it outside the realm of making it so part and parcel to the club. So if you have that club that historically says, we're a walking club, the only way you can go out is with the caddy, kind of making it really part and parcel to the country club. Or you have a club who says, we have other options. And even though you may not find them palatable today, you'll find it much better than having a large liability to pay. By the way, I'm not here to try to scare you. I mean, this business is scary enough. We all know it. trying to get enough members to keep the dollars flowing. I look at this as an avenue to pursue to help try to keep a really big unwanted expense out of your hair. And I think each and every one of you are going to have to seriously think about it for your own club. It's not an advertisement for me. I'm not going to retire off of providing services to golf clubs that deal with independent contractor status for caddies. There are much bigger cases out there and much bigger engagements that I do. But again, it comes back to us, the people who are responsible for the game, to somehow take an approach to this that makes sense to minimize the risk for our members. That's what they count on us for. When you take a look at federal law, one of the key determinations there really focuses on whether the caddy's economically dependent on the club or whether they're independent. Again, it goes back to control. At the federal level as well, they consider whether it's part of the club's business, integral to the club's business. There's not one place where one single test, one single factor is going to decide exactly what happens with the caddy and how they're classified. But, you know, the more of these that you can tick off, the better. What can you do to lessen the risk? I mentioned some of the things before. I've heard many folks talk about it, and I think clearly the lowest risk option is if you want to make them employees. It's the lowest risk with regard to dealing with the situation of what the caddies are and whether or not the caddies can sue you. That's the lowest risk situation in terms of that solution, but it's a high risk solution, I think, for a club. I think adding 50, 60, 100 people to the payroll at any club is going to upset your business model so much that it's going to be impossible to deal with. I also think it's going to create very high member discontent, and we know our members never complain to us. It's also going to create caddy discontent. I mean, the other half of this is many of the caddies really prefer the way it works right now. They don't declare this income, or maybe they do, maybe they don't. Hopefully they all have a special tax advisor who's telling them that they really have to. I'm not certain that's happening. You know, at the end of the day, the real threat, I think, to caddies and to having a real walking club is if you make them employees, if you really do treat them that way, if they are really paid for every single hour that they're there. I think that, more than anything else, will probably diminish the availability of caddies. I think the great number of caddies that exist want it to be exactly as it is today, that they get paid cash by a member, that they really do get paid based upon the service that they perform, that they really do have folks who look to them as the person they want to go out with and play the golf course. That's what we're looking to do. So that's the lowest risk legal approach to this situation. There are some other options out there. There's third-party sources, and both of these options that I put on the slide are kind of attractive to clubs because it takes you a little out of the middle. One, there are some services out there who actually provide caddy services, who treat the caddies as employees. They'll have them show up at your club. They'll have them show up at certain times for you. They'll make sure they're getting paid. It kind of takes away some of the local knowledge for you folks, although arguably, if the service is really spread and were utilized over a longer period of time, there's no reason to expect that those folks wouldn't sort of achieve the same sort of course knowledge that your existing caddies have. Also, that your existing caddies may end up joining that enterprise in terms of having a way to get their services out. There's some gig options that are out. Baggers is one that's I've been in touch with those folks. They're kind of like Uber apps. There's a number of them. Just so you know, I mean, Uber has, I think, pending at this time, 475 independent contractor lawsuits across the country in every jurisdiction in the United States that they operate in, and many of them overseas. It's a tough model, but again, if there are some options in terms of apps that are willing to take that risk for you, it might be something worth considering. It's not, I don't dismiss it automatically, but some of these apps work in a way where the golfers can communicate directly with the caddies through the app, through a request they make. It takes your caddy master, whose name we're now going to change to hopefully director of outside operations at some point in time. It'll take that person a little bit out of the mix. It also takes some of your control away. Go ahead.
So if you were making Caddie's employees, would they fall into a similar situation as like waiters and waitresses, in which you would be paying a lower minimum wage to them, and they'd be declaring their own tips?
So at present, I'm not aware of any place where the caddies could fall into that extremely low tip category, where you low compensated, where you can pay them $2.35 an hour. I think you'd be looking for, if you're aware, tell me, but I don't think there is any place that accepts that. It's not one of the positions that qualifies. I also think the chances of getting legislative change to allow that to happen are slimmer than me fitting into my size 32 hands again. I think it's going to be, you know, it's a thought, and it's one of the thoughts that arises really with everybody. Can we just pay them the $2.35 and then let them get their tips? No, I don't think it'll work as a solution. I think what it will do is it'll certainly create them as employees, and then you'll have just the risk of all the minimum wage. So you'll have the variance between whether it's $9, $10, or $15 that New York State's ultimately going to have, and that $2.35 will be sort of an automatic gift to them. That'll probably be like throwing bait to a lawyer. So these gig economy options, I think they're worth looking at. Go ahead.
Why couldn't each club have its own, so to speak, solicit caddies? Maybe, you know, big cosmetic, you have the same guy signing it day in, day out. Is that something you guys have thought about?
It is, and I think, you know, any way to create communication directly between the member and the caddies is helpful. The first complaint you'll get is from the caddy master, because they're going to say, well, you've taken away my job, and the answer is going to be, no, we still need you, we still have so much stuff to do on the outside. But I agree, if there's some way that, don't forget, at some clubs, they don't even have tea time arrangements. My club uses tea times every day. You sign up in advance. We have a really good idea who's coming out to play the next day. That makes it a little easier for us. I also will tell you my own personal experience. There's 3 or 4 caddies that I use regularly. I text with them. I try to arrange my game with them. I then tell the caddy master, you know what, I got Kyle lined up for 9 o'clock tomorrow morning. Please make sure he doesn't go out earlier than that. Kyle's perfect with that. He gets, instead of having to show up at 6:30 in the morning and sit around until 9 o'clock, he now can come at 8:30. Makes his life better, makes my life easier. But again, there's also, I vary my thing. I don't need a caddy for every round of golf. I like to walk every time if I can. I'm not going to carry my bag. We can do that after a certain time at my club as well. We can take carts as well. So there's times when, let's face it, if I want to play a 2.5-hour round of golf, which my wife and I regularly do late in the day, we'll take a cart for that because we want to sprint around and get out of it. We don't have a 5-hour window to have a 4-hour round of golf and lunch afterwards. We just don't have it. So there are options, but I think any time the clubs can get the members more involved with the caddies, it's going to be helpful. Yes?
I have 2 questions. With the board's not determined with its employee status, are the awards retroactive?
So, great question.
Are they prospective?
Statute of limitation in many places is 6 years.
So they could go back 6 years? And
Yes. Plus, they also have a little dinger known as liquidated damages, where they double the amount of the award for the 6 years. So you could be looking at medium range 7-digit numbers rather than low 7-digit numbers.
And I guess that's the reason. Have you ever considered whether waivers, the caddy signed a waiver saying I am an independent contractor and X, Y, Z, or
Definitely will help. So that definitely will help, and it's actually part of, I think, my next slide. Go ahead.
The last line. Can clubs can get together and pool of caddies?
So the question was, can clubs get together? I think it would be helpful. I mean, I think they have to use some caution that you don't all become joint employers with one another. But on the other hand, if you're encouraging caddies to go from club to club, am I running over already? No, I got a couple more minutes, okay. You know, if you get together with neighboring clubs to make sure that there's some interchange, that's going to help you, not hurt you. So in terms of solutions, how do you modify the relationship? Back to your question, paper. So 5 years ago, we put in place at Essex County a license agreement with all of our caddies, along with a class action waiver. What I like about this, number one, when the DOL shows up, unlike another club I dealt with recently, we have paper in every file establishing that the club and the caddy feel that there's an independent contractor relationship. That helps. The absence of paper, the absence of records kills you with the department of labor. It's not dispositive, but it certainly helps. The other thing is, as you said, it's much more likely that a lawyer is going to be trying to bring a case against the club rather than the Department of Labor. The lawyer is going to do it because they want to make money. If the lawyer can get together all 50, 60, 100 of your caddies in a class action lawsuit, much greater chance for that lawyer to maximize his or her earnings. With the waiver, what this requires is that the caddies have agreed in advance, and the Supreme Court is still very favorable with this, and they're going to take up a new arbitration case within the next couple of weeks. It's already argued. You know, this way, caddies have to bring their cases one at a time. So finding a lawyer, and lawyers, no disrespect to myself or any of you who are lawyers want the big group. They want to be able to have 50, 90, 100 people involved in a lawsuit. That'll generate more fees with them. They don't want to bring one case at a time. So that's one of the things you can do. Changing duties of caddy master, limiting the assignment of caddies, making sure that you're not the one who signs each caddy to go out there. Some clubs who rotate the caddies or go amongst people. That's not the right way to do it, most likely. The better way is to create some level of choice. Eliminate fee structures, the fact that you post the dues. I mean, look, if a person's an independent contractor, you know if you want that really good caddy, you're going to have to pay more for that than the person who's just going to be a bad caddy for it. Consider making alternatives available, and also resetting your member expectations. I mean, one of the things that I try to do with each engagement that I have with any club is, I'm a golfer. I've been around for 19 years at a private club. I understand that literally each and every decision you guys make is criticized by probably 10 to 50 members if you're lucky, perhaps all 250 to 300 of them if it happens to be one of those hot topics. So you have to figure out some ways how to communicate this. Takeaways?
Excuse me, one quick question.
Please.
Is clubs make it mandatory to sign that waiver, or is that crossing the line?
No, we do. We make it. It's very easy, and in terms of rollout, the time's not now in the middle or end of the season, the time is before. So you have a trickle in theory for the the golfers start trickling back in March, April, and it starts to build, so too do the caddies. That's the time to really roll this out, so if you're going to consider it, it's really over the weekend. I'll just take one more thing that you all should keep in mind, because, we got another question back there, go ahead.
Actually, it's two. The first is regarding the paperwork. Do you recommend that being done on an annual basis every year, or if you've had a caddy for 15 years, is one document from 1979 to now?
We do it every year. I mean, one of the things we heard when I suggested rolling this out 6 years ago at Essex County was, these folks are never going to sign these forms, it's going to create a big snafu. You know what happens? They come in, they sign the form, it goes in the file. We do it each and every year, and so we give them a copy of it. We have up-to-date information on every caddy. We have an information page on them so that we can reach out to them if there's some issue that arises. It's really quite easy, to tell you the truth.
And my second question is regarding posting the fees. If we change the terminology to recommended fee, does that give us a little more latitude?
It does. I think it's the posting part of it, as opposed to if a golfer asks your director of outside operations, what's a normal fee, then certainly a response can be given to that. I think when you post it and you tell it, and you're really trying to control how much the contractor gets, that's an indicia of control, because suggested fees, I mean, we all know that. That's what folks are going to really market to. I'm not trying to create something where somebody's going to be a bidding war for caddies, but ultimately, there has to be a little bit of that. The caddies have a preference too. They'd much rather go out with the person. I have a fairly low handicap. We'll see what I shoot today. It may be 100. It may be at 70. Who the hell knows when you show up and play golf? But they want to go out with the person who's got a 2 handicap, the member who's got a nice demeanor, that's not every time you hit one, 8 feet offline, it's their fault. They want to go out with the member who's going to pay them the $100 a bag rather than the one who's going to pay them the $65 a bag. That's the nature of an independent contractor. That's the last point I was going to try to get to with the last bullet. When you think about what a really independent contractor is, think about when you have work done in your house. That person who comes and shows up, it really is a bidding and an interview process, and it's a, how do I judge this person's expertise? What recommendations have I got? That person's going to quote you a price. You may have a different price in mind, but ultimately, that guy who fixes your cabinets may decide he wants to walk away because it's not enough, and you may decide you want to walk away because it's more than you're willing to pay. That's what an independent contractor relationship looks like.
Could you just elaborate a little bit more on the uniform requirements? That we pretty much achieve most of the recommendations. We need to schedule and money for others.
Very difficult.
Like clips and name tags.
Yeah, I would probably ditch the name tags. I would probably, the bibs, I think you can make an argument that it's a way to help identify the person who's standing in the middle of your fairway that's not just another golfer. If you're going the route of the full, Augusta-style jumpsuit, really just a uniform. How much do you coordinate the fact that they wear khaki shorts and a red shirt versus your khaki shorts and your red shirt that you provide them with? So I don't think it's the most important factor. I think it can be hurtful to you, but I don't think it's the most important one.
Glenn, one more question over here, Glenn, and then we'll turn it over to Randy.
Sure.
Hi, I'm just curious if you've looked at clubs that have Caddie scholarship programs.
Yeah, we have it as well. Certainly one of the factors that gets into it. I mean, it's a hard one to really deal with because for the most part, it's a nice thing that clubs are doing to give back. I don't think it's going to be something that ultimately decides whether the caddies are independent contractors or not. I know most of the New Jersey State Golf Association, in fact, runs one larger pool that covers all the caddies. So to the effect that it goes to a larger pool run by a different organization, I think you have some level of separation there that helps you. Would it be best if it didn't exist? Perhaps, but I think the benefit outweighs the risk. They can tell. You could ask me, sure.
What is the impact of outings where the club is actually paying for caddy fees?
And I think one of the things you have to do on that is you have to migrate more toward the club not taking an amount of money from the outing to pay to the caddies. That the outing people are told the caddies are there as independent contractors. The fee that the caddies are paid is between the people that they're accompanying and the caddy. I think you have to really migrate that way because all of a sudden you have 72 cars going out for a big tournament that drive everybody out. The caddies get off, and then they're told what they're going to get at the end of the day. And I know that's the case at almost every event. Thank you very much for your time.